everyone. This is Mark Movsesian. I'm the director of the Center for Law and Religion at St. John's, and I'm joined by my colleague and friend, the center's co-director, Mark DiGirolami, for another episode of Legal Spirits, which is our podcast series on cases and issues in law and religion. So today, Mark, we're coming back to a topic that we've addressed a couple of times already in earlier podcasts. In fact, it was the subject of our first podcast about a year ago. So happy anniversary, Mark. It's been the year we're doing this.
And to you.
So, and the topic is the wedding vendor cases. And we're talking here about cases involving commercial wedding vendors, florists and bakers and, videographers and printers, who decline to provide services for same-sex weddings because of the vendor's sincere religious convictions. And in doing so, the vendors arguably violate state anti-discrimination laws that prohibit public accommodations from discriminating on grounds of sexual orientation. The vendors in turn argue that they have a right to a religious accommodation under federal or state law, either the federal Constitution or RFRA. I guess the federal RFRA doesn't come up very much, but state RFRAs do, and also state constitutional provisions. And although the law in this area is kind of a mess, there are different rules in different jurisdictions, the predominant test here is something called the compelling interest test. And under that test, if the state imposes a substantial burden on religious exercise, then the state must show that it has a compelling interest that justifies imposing that burden on the plaintiff, and also that denying an accommodation is necessary to achieving that interest. This is the so-called least restrictive means test. It's essentially a balancing test that has to be satisfied.
Now, Mark, I think the last time that we talked about this, and I think at least in the recent past, the vendors have been losing these cases.
That's
Isn't that
correct.
right?
That is correct, Mark. The vendors have been losing these cases for the past several years. But the reason we're doing this podcast now is that the tide may be shifting a little bit in favor of the vendors, especially where speech is involved. So last year there was a case at the Supreme Court called Masterpiece Cake Shop, a rather narrow decision. There actually was a case in the UK also called Asher's Bakery. We're not going to talk about that, but there was another case in the UK sort of like that in which the vendors won. And then we have a number of lower court decisions in the last few months which are coming out in favor of granting accommodations. And these cases typically address free speech claims as well, which also involve strict scrutiny and a compelling interest test.
And we should add, Mark, that Masterpiece Cake Shop itself did not involve that question. So that question was briefed and argued, but
the speech question.
The speech question. It wasn't the direction in which the court ended up going. They went with a overt religious discrimination angle and a free exercise angle. But the idea, I take it in the speech for the speech claim, and we'll talk about this more, is that if, and it's a big if these activities or some of these activities qualify as expression, then there's a long line of cases, the most important of which is the Barnett case decided by Justice Jackson, holding that the state cannot compel people to speak in ways that they object to or to say things that they don't want to say.
Right, and so we'll talk about all of this. In today's podcast, we're going to explore some of these recent cases and ask whether they suggest a change going on. Now, the results aren't uniform, for sure, but maybe something is happening in the lower courts. And then we'll speculate about some possible explanations. Maybe it's just as simple as this. There's a new crop of judges, especially on the federal appeals courts, and that's influencing the results in these cases. Okay, so the first case we want to talk about is a case called Arlene's Flowers. Mark, why don't you tell us about that?
Sure. So this is a case involving a Washington state florist. Baronelle Stutzman is her name, and she creates floral arrangements for various occasions. She serves everybody in her store, including the plaintiff, for over 10 years before this case, but she declines to create floral arrangements for same-sex wedding ceremonies. And so she was sued by somebody who wanted her to create a floral arrangement for his gay wedding, and she was sued under Washington state's anti-discrimination laws. So the case has a somewhat involved procedural history at this point because there's been sort of ongoing litigation. The case was remanded by the Supreme Court in light of its decision in Masterpiece Cake Shop. But basically, she lost below. She appealed to the Supreme Court. The case was remanded by the court in light of Masterpiece Cake Shop. She lost again at the Washington Supreme Court. which restricted Masterpiece Cake Shop to overt religious discrimination by adjudicators, not by executive branch officials, which was the case in Washington, where it was the Washington State Attorney General that sued her. And now she's filed a new cert petition, the response for which is due next month.
And actually, Mark, I went back and looked at the Washington Supreme Court opinion on remand, and it's really quite astounding. They basically just cut and pasted from their first opinion, and it sort of, sent it back up to the Supreme Court without even really bothering to do a new opinion. I don't think I've ever seen something like that before.
Yeah, that is kind of interesting and perhaps suggestive about the way that different judges with different perspectives on these issues feel about them. Okay,
so now we have a cert petition again from the Washington State Supreme Court opinion. And what's the cert petition argue?
All right, well, so there are two arguments in the case, just as there were actually in Masterpiece. The first argument is a free exercise clause claim. And the claim is that the state is compelling her, the florist's participation in a ceremony to which she has religious objections in violation of her religious free exercise. So here there's a question about whether this famous case that we've talked about on other occasions, Employment Division versus Smith, really covers something like what she is alleging as within the free exercise of religion. Actually, I was struck by how much emphasis there is in the cert petition on the idea that, quote-unquote, history and tradition forecloses an attempt by the state to compel Stutzman's participation in a religious event.
Well, that's right up your alley, Mark, history and tradition.
I guess, right, to a hammer, everything looks like a nail, but it is. I was struck by that in as much as we've seen that kind of argument in a number of other cases, Establishment Clause cases. It seemed like that argument was keyed, at least to some of the justices. But underneath this free exercise claim might really be a plea for the court to revisit Employment Division versus Smith, as it has been suggesting. The court, or some of its justices, has been suggesting that they don't really like Smith all that much.
No, we talked about that in a recent case, in a denial of cert. I think there was a statement by Justice Alito, joined by some of the others, hinting that maybe it's time to revisit Smith.
That's right. Okay, so there's the free exercise claim, and then there's a compelled speech claim.
Which really might be more important given these other cases.
That's the way that a lot of people felt about Masterpiece Cake Shop going into the case. They thought, this is really, if the court's going to decide this case is going to be on this angle, and that was not to be, which shows just how much we know. But this compelled speech argument does make its appearance again in this petition, and the argument here is that the floral arrangements are a form of expression and therefore protected expression. So the Washington Supreme Court rejected that claim. It said, look, I'm sorry, floral arrangements or artistry, that's not a form of protected expression. And in doing so, arguably, it came into conflict with other circuits that have come out the other way.
Right, and we should say that if it's not a matter of free expression, then it becomes a much more difficult argument for the vendors, because there are cases from the civil rights movement, for example, a case called Piggy Park, in which courts say if you're just refusing to serve people on the basis of status, you just don't like them, then there's no such thing as a religious accommodation for that. But what these cases are now suggesting as well, but if it's not about status, it's about I don't want to say something I don't believe, then it's a little bit different.
Yeah, and I think that this point was emphasized, at least in the cert petition, that this is a relevant distinction. The particular history here of service, not just of gay people in general, but of this particular plaintiff over a 10-year period, was emphasized in the brief. So we'll see how much water that holds with the Supreme Court if this court takes the case. In other contexts, as we know, Mark, the court has not accepted this kind of distinction between status and belief, or the distinction between somebody's identity and between their conduct. So we'll see whether it works here.
Right, so we'll see. So Arlene's Flowers is a case in which the vendor lost again. Now it's up on a cert petition, and next month there'll be a response filed. We'll see if the court takes that case. But there were a couple of other lower court opinions over the last few months in which the wedding vendors actually were able to win. And so, 2 or 3 cases doesn't really make a trend, but there's a joke about that, right? You get 3 cases, that's a trend. But they do suggest maybe something different is happening. And one of these lower court cases, which is suggesting that maybe something different is happening, is a case called Telescope Media Group, which is an 8th Circuit opinion decided a couple of months ago. It's a 2-to-1 opinion. The author is Judge Strass, who is a former law professor, and actually a Trump appointee who's thought to be on the short list for a Supreme Court appointment. So this is significant. So the facts in this case are sort of familiar. This case involves videographers, and they produce videos for traditional weddings, but they decline to produce videos for same-sex weddings because of their religious beliefs. In Minnesota, there's an anti-discrimination law which would require them to do both. That is to say, if they do videos for opposite-sex weddings, then they must also do videos for same-sex weddings. And the videographers sued for an injunction preventing the Minnesota law from applying to them. So the district court dismissed their suit, but then it got up to the Eighth Circuit, and the Eighth Circuit ruled in favor of the videographers.
Right, and we had a similar kind of resolution of the case involving the compelled speech claim. The claim is basically that the way in which the state applies its public accommodations law violates the speech clause because the state does so in a content-based way. So the state, it says, is using speech in one substantive context, that is, speaking about marriage between a man and a woman, as a kind of trigger for compelling the videographers to speak in another substantive context, speaking about a same-sex wedding. That's a content-based restriction on speech. The court says, and these various petitions now are saying, that should trigger strict scrutiny, and in this case, that violate strict scrutiny.
Right, because strict scrutiny would require that the state has a compelling interest justifying what it's doing. And in the Eighth Circuit, Judge Strass said, look, there's no compelling interest here. Now, you've got to be careful about this. So preventing discrimination in public accommodations, Judge Strass says, that generally is a compelling interest. But regulating offensive or discriminatory speech is not. And this comes to the distinction we were talking about before. So what Judge Strass is saying is the anti-discrimination laws can regulate conduct, but they can't regulate expression. And what's going on here, videotaping a wedding, that's expression.
Right. Now, there was also a ruling on the free exercise claim. The free exercise claim, the court said, can proceed. It talked about the hybrid rights theory of Smith. It's a speech plus religion kind of claim. You know, that theory has come under some scrutiny, the hybrid rights approach, principally because the only time where such a theory would make sense is if you have two claims of right that are insufficient of themselves but sufficient together, whereas here it's not really clear to me exactly what the court is saying. It already said that there's a speech claim that is sufficient on its own, so why you need a free exercise claim to sort of that's insufficient on its own to attach to a speech claim seems a little strange.
Well, and Judge Strass said that. He said probably it doesn't make any difference, but, you know, they did raise this claim, and so they're entitled to pursue it. And so the Eighth Circuit remanded back to the district court to pursue this about whether an injunction would be granted, although it seems pretty clear the plaintiffs are going to win when it goes back to the district court. So this is a victory for the vendors. Now, we should say there's a long dissent in the case by Judge Kelly, who is an Obama appointee who was thought to be on the SCOTUS shortlist in that administration. So Strass in this administration, Kelly in the last one. These are both heavy hitters. And Judge Kelly disagreed with Judge Strass both on the speech analysis and the free exercise clause analysis. In particular, she was saying that, well, this really is conduct going on. This is videotaping a wedding. This is a commercial service. It's not really speech in the same way as other things are. And also, she said, in light of the compelling interest in ending discrimination in the marketplace, this would pass strict scrutiny anyway.
So interesting, Mark, trying to pull the case closer to a case like Piggy Park. Right?
Yes, exactly.
So this is really, it seems to me, the ongoing fight in this sort of speech, non-speech dispute.
Exactly. You know, I was just telling my 1Ls in contracts this morning that being a good lawyer is being able to identify patterns. And what you see here is Judge Strass is saying, well, this fits one pattern of cases, and Judge Kelly is saying, no, this fits a different pattern of cases, and that's really what they're talking about. Okay, that was one case. The other case that I thought was interesting, Mark, is a case from the Arizona Supreme Court, which was decided this fall, and this is called Brush and Nib Studio. This is a state Supreme Court opinion. This was also a close decision. This was a 4-3 decision. And in this case, the wedding vendor was an art studio which did custom wedding invitations. And it declined to design custom wedding invitations for a gay couple because of the vendor's Christian convictions against same-sex marriage. They didn't want to convey a message of endorsement of same-sex marriage. And so They ran up against a City of Phoenix anti-discrimination ordinance, and they sued for an injunction that that ordinance didn't apply to them. Now, you would have expected, based on some of the cases in past years, that the vendors would have lost here, but the Arizona Supreme Court ruled for the vendors, ruled for the studio, both on free speech grounds and also free exercise grounds under the state version of RFRA.
Right, and so, but otherwise, the claims, again, they're talk about patterns. These are just sort of recurring over and over. So on the free speech ground, it's very similar to the approach in Telescope Media. The court says this is a content-based limit on speech and therefore compelled speech. So it has to satisfy strict scrutiny. There's no compelling state interest that can justify requiring vendors to express an opinion that is not their opinion. In fact, that is the opinion that they don't hold, that they oppose. And the Arizona under the statute, the Arizona statute, the RFRA statute,
right, which is, just so our listeners understand. So a number of states have statutes that are patterned on the federal Religious Freedom Restoration Act. Arizona has one of those. They call it something different, but it's essentially the state version of RFRA.
Good. And so again, the substantial burden on plaintiffs' religious free exercise exists, and there is no compelling state interest. So held the Arizona Supreme Court. Also, it held that even if there were, this is not the least restrictive means of achieving that interest. So
yes,
you could have a narrow exemption for the speech of religious firms that wouldn't unduly compromise the state's interest in ending discrimination in the marketplace.
Yeah, I thought this was very interesting because this has come up in other cases too. What the court said is, well, forcing these vendors, this art studio, to actually express an opinion that they don't share, they don't have, actually is not the least restrictive means of promoting the state's compelling interest in ending discrimination. And what they said is, look, there's no evidence that if you allow religious vendors to avoid saying things they don't want to say, that's going to cause other firms, other vendors, whose services do not involve speech to discriminate against gay customers.
So in some ways, this case is a little narrower, right, Mark, than some of the others, because this one really does involve words, whereas
yes,
the other one involves activities, expressive conduct, right, is what the term for this is, right?
Correct.
Making flowers or making videos, right? I mean, so certainly flower arrangements are different than, in kind, perhaps, are different than actual words on a particular invitation, let's
You're
say,
right, Mark. You're right. And the court again and again says that this case, that is the Arizona court, says again and again that this case involves pure speech.
Right. Correct me if I'm wrong, but the English case actually was a speech case like this, right? Asher's Bakery was sort of similar to the Arizona case in that way, more similar than to some of the other ones.
The listeners can go back and listen to that podcast, but Asher's Bakery involved a baker who didn't want to make a cake promoting gay marriage.
Right, with the words.
With the words, right.
With the words.
And so it's the same sort of idea here. But it's interesting also, this is a balancing test, both in Brush and Nib and also in Telescope Media, I think in Arlene's Flowers. In the end of the day, it's the same thing. It's a balancing test, and the court is trying to decide, well, assuming there's a compelling interest here in ending discrimination, is applying that to a particular vendor in a particular context, is that enough of a justification for burdening the exercise of religion? Okay,
well, so now let's get to some of the sort of 30,000-foot view about what explains this change, Mark. Any explanations for the kind of shift that we're seeing, at least in some of these cases?
Well, if it is a shift, and again, I want to tell our listeners, we don't want to overclaim here.
Sure.
I mean, these are just a couple of cases, and who knows, but if there is a shift, we can speculate on what might be causing it. I said just a second ago, we were talking here about a balancing test, and that's what strict scrutiny is. That's what the compelling interest test is. It's a balancing test in which the judges are weighing the state's interest against the benefit that comes from promoting the state's interest against the costs that are borne by particular plaintiffs. And that kind of test, as Justice Scalia noted a long time ago in the Smith case, that kind of test leaves a lot of room for subjectivity, and different judges operating completely in good faith are going to strike the balance differently.
Right. So you can kind of combine the priors that kind of test smuggles in or imports with the idea that at least in the federal courts, you've got a new group of conservative judges on the federal courts of appeals, let's say, given the given the work done by the Trump administration on this issue over the last few years. You can see it in telescope media, at the very least.
For sure, because once again, this is Judge Strass, who's a Trump appointee who's thought to be on the short list for the Supreme Court, against Judge Kelly, who was an Obama appointee who was thought to be on the short list in that administration.
Right, and I don't want to be, and I don't think you do either, sort of crassly partisan about these kinds of questions. As you said quite rightly, given the amount of subjectivity and the reliance on background factors and beliefs that the test itself calls for, it's no surprise that different people with different backgrounds and different sets of belief will come out differently with respect to this kind of question.
Of course, Mark, no, and you're quite right. I want to avoid the mistake people sometimes fall into of vulgar realism, that all this is just partisan. And that's not what I mean. But judges coming from different perspectives are going to see these cases very differently. They have different social networks. They have different priors that will influence how they're going to view the balance in this case. There's been really interesting work done by Dan Kahan about something called cultural cognition, which suggests that people will evaluate facts, and that's what's going on here. The judges are evaluating the facts of these cases, how the law applies to different facts. They're going to judge facts very differently depending on the ideological and moral commitments that they have. Those things will influence how they view these cases. And it's not surprising. We have a very polarized politics right now. And judges who are appointed by Democratic administrations can be expected to have a different set of ideological and moral commitments with respect to these issues than judges who are appointed by Republican administrations. Everyone knows this.
Now, we can ask a different set of questions, actually, Mark, in light of what we've just talked about, which is we can ask a doctrinal question. What do these disagreements or the change in direction, if it is a change, what does it say about the prevailing doctrinal approaches used to resolve these cases? Does it show that, Justice Scalia had a point in criticizing this kind of balancing test? What are the alternatives? I suppose the court could take a narrower view of what religion means. This is something that some scholars influenced by originalism have said, and I'm thinking here of our friend Philip Munoz at Notre Dame, who's made these kinds of arguments. On the other hand, one wonders whether these kinds of disagreements are likely to occur no matter what test is used, because at a certain point the necessity to make judgments about contested matters really can't be avoided. What do you think about all that?
Well, I think you're right. I think this does show what Justice Scalia talked about. I'm not saying I endorse the Smith decision. The Smith decision is controversial and has lots of problems. But if you think about what Justice Scalia said in that case, he said, look, this balancing test is just totally unpredictable and vague and gives far too much discretion to judges. And you see that thing happening. Now, it might be, and I think I probably would take this point of view, it's, as you say, this kind of discretion, this kind of balancing is inevitable, really, in these areas. And if you have a culture that is as divided as ours, you are inevitably going to get differences like this.
One last thing to think about, Mark. So we've talked about explanations for the change. We've talked about doctrine. I had a kind of a question about institutions, or especially with respect to the judicial institution and what the prevalence of these cases say about, for example, the Supreme Court's present composition. To me, it's no surprise that the court is getting lots of appeals like this coming from states like Washington, right?
Right. And in fact, if you think to our last podcast about the abortion cases, we said the same kind of thing. That there's now, with the changing composition of the Supreme Court, there's a lot of interest, a lot of enthusiasm in trying to push and see what happens now. Maybe they will overrule Smith. Maybe a new composition of judges at the court will change how the court decides these cases.
Now, look, I think it's true that the Supreme Court is likely to view these kinds of challenges in this context, in the abortion context, much more favorably than do many of the state Supreme Courts from which these challenges are coming. Not always, as in the case of Arizona, of course, but often. The trouble is that the court can only take so many of these cases, and I think you can even see in the way that the Washington State Supreme Court kind of dismissively disposed of Arlene's Flowers, the sense that, well, there are a lot more of us than there are of you, so to speak.
Well, that could be. Again, I want to just say, I don't think, I can't remember a case in which a state Supreme Court simply cuts and pastes most of its analysis and sends it back up as though, we already told you once already. I know there are some other issues, and the Washington Supreme Court did talk about these other issues. For example, if there's bias alleged, does that bias have to be on the part of an adjudicator, or can it be on the part of an advocate like the attorney general? So there are some. I don't want to. It wasn't simply a diss. I mean, they did discuss some of these things too, but It was quite striking. Yes, there's more of them than of the court. The court can't hear everything. Also, Mark, I think about Masterpiece Cake Shop. I mean, after all, the court just did have an opportunity to decide a case like this, and the court punted.
You're right, which is essentially a kind of license for lower courts to continue deciding, and not just lower courts, I should say. Most of these cases are going to be decided, practically speaking, at the administrative tribunal level. So
Correct.
you have the majority of these cases, they're being decided at all of these civil rights panels and commissions that exist all over the country, right?
Right, and in the nature of things, not everything is going to get to a court or the Supreme Court. But also, Mark, what I was trying to get at is the Supreme Court itself might not be that interested in hearing these cases, just as they might not be interested in hearing the abortion cases.
No, you're right. And the court's natural instincts toward minimalism and deciding narrowly is only going to, in some ways, reinforce the sense in lower tribunals of various kinds that they're pretty much at liberty to do what they want, which in turn might suggest that the result that you're likely to get is going to depend upon where you live.
Yes, that's very true too. And what I meant to say is not that the court doesn't want to hear these cases. The court may grant cert, but come up with a minimalist opinion, which leaves a lot of discretion to lower courts. Okay, look, well, we'll see. We'll keep an eye on this for you. For now, this is Mark Movsesian and Mark DiGirolamo from the Center for Law and Religion at St. John's with another episode of Legal Spirits. You can find past episodes archived on iTunes and also at our website, lawandreligionforum.org. See you next time.